to everyone. Before we begin, I'd like everyone to take out your phone, and if you have not subscribed to these 3 newsletters, scan the QR codes. These are all fantastic organizations. In addition to being hosted by the Berkman Klein Center, this event is also co-sponsored by the AI Safety Student Team and the Harvard Law AI Association. In addition to co-sponsoring events like this, we run workshops, fellowships across the university every semester. So if you'd like to stay in touch, get involved, sign up right there. Also, the Berkman Klein Center has a new AI tool. If you're interested, you can go to this link at the bottom and talk to an AI agent during the presentation, about the presentation. Enough said, let's kick it off. Thomas.
It is my pleasure to introduce Professor Gabriel Weil. He is one of the leading scholars on how we can use the law to mitigate the worst risks from AI. He's an associate professor at the Tort University Law Center in New York, a non-resident senior fellow at the Institute for Law and AI. His work has been covered in popular outlets such as Fox, and he regularly consults with legislators and other AI policymakers. Before turning to AI, he did climate work for the Climate Leadership Council and the White House Council on Environmental Quality. He holds degrees from Georgetown, Pace, and Northwestern, spanning law, environmental policy, political science, and physics. Now, please join me in giving a warm welcome to Professor Gabriel Weil.
Thank you, Thomas, and thank you all for coming. So I want to talk to you today about the role that tort law can play in mitigating AI risk, and I want to convince you of 5 key propositions. So first, that AI risk is a policy problem, so both it's something worth worrying about and that policy has something to say about it. That ex post liability is generally preferable to ex ante regulation. That for the things it works for, it's the main tool we should rely on. But that negligence and products liability, which are the default liability regimes that would apply, are likely to be inadequate to leave significant gaps. And so we need stronger forms of strict liability, primarily abnormal dangerous activities, supplemented by vicarious liability theory. Fourth, the judgment-proofness that AI companies may cause harms that they cannot be practically held accountable for ex post is the biggest problem with the ex post approach to liability. That this problem can largely be overcome through liability insurance requirements and punitive damages in near miss or warning shot cases. And finally, despite my general bullishness about liability, you can't do everything. I'll talk a little bit about the rules that I think remain for other policy issues. Okay. So first, I don't have time to go into a deep argument about why you should be worried about AI risk. I'm just going to present one set of data points here. This is what I think is the most important result from a study done by the Forecasting Research Institute that brought together super forecasters. These are people that have a strong track record of making accurate predictions on relatively short-range events that we can check their accuracy on, and then experts on different kinds of catastrophic existential risk. And so the headline that came out of this study was, even after they had several hours to debating each other, there was still a roughly order of magnitude disagreement between the median AI risk expert that said there was a 3% risk of human extinction by 2100 from AI, and the median forecaster that said 0.38%. I think that is noteworthy, but to me the bigger thing, the bigger takeaway from the study is the 0.38 number from the super forecasters. So 0.38 is more than 1 in 275. I don't think you'd get on a plane that had a 1 in 275 chance of crashing. I certainly don't hope you'd put all of humanity on that point. And so I think that suggests it's worth paying some attention to. But is it worth policymakers paying attention to? Maybe it's just a technical problem that technical AI safety researchers can focus on, but the law doesn't have anything to say about it. And I think that's wrong. So I think it is a policy problem. I think AI risk is a market failure, that building and deploying advanced AI systems pose a risk of harm to third parties that by default is not reflected in market prices. It's not borne by either the developers of these systems or their users or any intermediaries in the supply chain. In economics, this is known as negative externality. It's a standard finding in economics that activities that produce negative externalities tend to be overproduced. Similarly, activities that produce positive externalities tend to be underproduced. And economists have a standard prescription for what to do about negative externalities, and it's to try to compel the generators of them to internalize them. So that's why I think ex post liability is well positioned to do that. So yeah, the standard economic response is to try to internalize them for diffuse externalities that are hard to trace to a particular actor. We tend to use something like a Pigouvian tax. So climate change is well addressed by a carbon tax. It's pretty easy to measure the carbon content of a fuel. We know roughly how much burning that fuel is going to contribute to climate change. There's disagreement about how bad climate change is, but not about the proportionate impact of different activities. And so we can argue about what rate the carbon tax should be at, but we know how to assess it. Whereas it would be pretty hard to do sort of ex post liability for climate change. You drove your car 100 miles and then someone's house flooded in Bangladesh. Are they going to sue you? Probably not. Conversely, for AI, it's going to be much harder to do something like an AI risk tax, because it's very hard to measure AI risk ex ante. But it's much easier than in the climate context to attribute harms ex post. It's likely to be specific people who suffer harms from specific systems, and they can sue the people responsible. So that's some intuition as to why tort liability is a good tool here. But you might be asking, why not ex ante regulation? Why are we trying to do pricing at all? And so, I tend to think liability and ex ante pricing, depending on the domain, is an underrated tool more generally, and we rely too much on ex ante regulation generally. But I don't think you have to be persuaded of that to be convinced that in this context we should rely particularly on ex post liability. And that's for two key reasons. So one is that if you're going to impose ex ante regulation, you need to have some level of social consensus about how big the risks are, and to know how much ex ante cost is worth you can justify. So if you're going to do tight prescriptive rules or FDA style approval regulation, that's going to be very costly. If the risks are very low, then that wouldn't be worth it. Conversely, if you're going to do just very low cost disclosures or transparency requirements, which is mostly what's on the table politically right now, that's going to be underpowered if the risks are very large. And we have orders of magnitude social disagreement about these risks, from people like Mark Andreessen, who think that the risks are basically fake, they're approximately zero, to on the other extreme, someone like Ilya Zhutkowski, who thinks it's more than 99% that it's going to cause human extinction. Maybe 20 orders of magnitude disagreement. There's obviously lots of people in the middle, but it seems like hard to afford the kind of consensus we need. And even if you did, I wouldn't be confident that it was truth tracking, because it's a genuinely hard epistemic problem. So that's one challenge. But even if we had the political will, we had some rough estimate that we agreed upon, that we thought was pretty accurate about how big the risks are, I still think it'll be pretty hard to do effective ex ante regulation, because we don't know how to write down a set of rules that will make AI systems safe. Most of the expertise needed to identify and implement cost-effective risk mitigation measures is concentrated in the private sector, in the companies that are building these systems. You could try to move those people into government, but salary schedules and cultural rifts, I think, would make that difficult. And so it's much more attractive to try to shift the onus to the companies that are building systems and generate these risks, reduce them, and that's what liability does. It aligns their incentives with the broader social welfare, and so I think that's why we should want to rely on liability to the extent we can. This is not advancing.
Just click inside. Just click inside.
Okay. So the question is, some people might think, and I've heard people recently saying this, we don't have to worry about AI risk at all, because tort law is just going to handle this. I don't think that's right. So I think there's a couple gaps in the current liability system. First of all, about whether there will be liability at all under certain circumstances. So I think most of you have taken tort law. You know that negligence requires the plaintiff to prove that the defendant breached their duty of reasonable care, and that had they exercised reasonable care, that would have more likely than not prevented the plaintiff's injury. And the scope of this negligence inquiry the scope of this breach inquiry tends to be quite narrow. So if a driver, unintentionally runs over a pedestrian with their car, courts don't ask questions like, well, was the value of this car trip to the driver, worth the risk to the pedestrians? Was the extra value they got from driving an SUV instead of a compact sedan worth the incremental injury risk to pedestrians? Those are outside the scope of the negligence inquiry, the breach inquiry. Driving is treated as social useful activity, and the question is, well, were you drunk? Was the driver drunk? Were they texting? Were they speeding? And so I expect a similar analysis to play out in the AI context, where courts don't ask questions like, well, was it reasonable to train and deploy a system with these high-level design features, given the current state of AI alignment and safety science? I expect those to fall outside of the negligence inquiry, outside of the breach inquiry. Instead, I expect courts to assess whether there was some off-the-shelf alignment technique or safety practice that the company could have implemented, that they failed to, and if they had implemented it, would have prevented the client's injury. That will surely sometimes lead to liability. There's going to be some responsible actors that aren't even using all the off-the-shelf alignment techniques and safety practices that a reasonable person would. But that's inadequate if what you think we need is to drive, is to motivate discovery of new alignment practices. Sometimes if we need to motivate AI companies to slow down, if they think they don't have the techniques they need to make their model safe, maybe under some circumstances what you need them to do is wait 6 months until they have better interpretability tools. All those things I think are going to fall outside the scope of the breach inquiry. Now, products liability is often called strict liability, so you might think that's better. I'm somewhat skeptical of this claim. So even if products liability applies, which it might not to pure software systems, I think those are likely to be treated as services much of the time. But even where it applies, I think it's not going to end up, the analysis is going to end up looking that different from negligence analysis. So the kind of products liability that's that's closest to genuine strict liability is manufacturing defects. So if an individual unit of a product comes off a production line, deviating from its specifications in a way that makes it unsafe, or if it's a lemon, like they sometimes say, then the manufacturer can be held liable regardless of, say, how much they invested in quality control. That's pretty strict. But we're not really going to have manufacturing defects, at least for the software side of AI systems. It's pretty easy to make perfect copies of software. And if there were some sort of copying error, that's just not the main source of risk that we're worried about. Most of the risks we're worried about would fall under design defects. And the test for design defects is much more negligence level. So the test that most states follow is, was there some reasonable alternative design that would have prevented this injury? Where reasonableness is a balancing test that weighs, price and performance and other product features against safety. And so that's going to look pretty similar to the negligence breach analysis in practice. And so I don't think, even when AI systems are treated as products, that's going to be a game changer. Okay. But I do think it's important to have strict liability, and I have a paper where I go into different normative theories of tort law. I don't have time to get into the weeds of that here, but I show that a wide range of theories converge to support strict liability in what I call core cases, which are third-party harms, so harms to non-users, non-consenting third parties that arise from alignment failures, as distinct from capabilities failures and misuse. So users, they're consenting to these risks. They can decide to use a different product or to abstain from using AI at all. And AI companies have incentives to protect users. Even absent liability, because it's not going to be good business if your users are always getting hurt. But those incentives don't apply, natural market incentives don't apply in the same way to third parties. And so that's a reason to think the second versus third party distinction matters. If a user is doing something bad with the system, it's at least less straightforward that should give rise to strict liability for the developer. I think that's a much more nuanced case. Again, I get into details of what I think the test should be there in that paper. But I think the normative consensus that I want to argue for really only holds up in these core cases of third-party harms arising from alignment failures. So an example of alignment failure would be, in general, these are cases where the system is doing something, either pursuing a goal that diverges from what the user or the developer wanted, or through means that the user or the developer would disapprove of. So if you get into a Waymo and say, give me the airport, I'm in a hurry, and it decides, that means it should ignore traffic laws and ends up running over pedestrian, that would be alignment failure. Whereas if a sensor fails and it accidentally runs over a pedestrian, that would be a capabilities failure. If you tell it to run over a pedestrian, that would be misuse. Okay. So assuming we think strict liability is a good idea, you may think, well, how can we get there? I think there's both common law pathways and legislative pathways. So first let's talk about common law. So the primary doctrinal pathway that I think courts rely on is the abnormally dangerous activities doctrine. So you may remember from your torts class that if you're blasting with dynamite or putting on a fireworks display, or there's a related doctrine related to wild animals, so if you're keeping a pet tiger, and someone is injured in a way that arises from the inherently dangerous nature of that activity, then you can be held liable regardless of the level of care you exercise. So these are activities that are both uncommon and still pretty dangerous even when reasonable care is exercised. Only a handful of companies in the world train frontier AI models. At the very frontier, it's like 3 companies. If you want to expand it a little bit, it's maybe 10 or 12. The leaders of these companies say they don't know how to make them safe, and they're trying really hard, but they can't promise that their systems will be safe. So I think that's a strong suggestion that reasonable care is inadequate. I think it's going to be counterintuitive to judges to say that a subset of software development is abnormally dangerous in the same way that blasting with dynamite is. But I think if they have an accurate understanding of AI risk, then it does follow from the doc. At least in the short term, when training these powerful models is uncommon. I think it's likely that in the long run, algorithmic efficiency, compute increases and decreases in compute costs will make it much more feasible for a larger universe of people to train these models and certainly to deploy them. We might come to a point where AI agents that are capable of committing conduct that would be tortious for a human are widespread. We can no longer say it's uncommon. Now, there is a line of scholarship. There's a prominent paper by Chevelle and Polinsky that says this uncommonness requirement doesn't make any sense. It should really be all about whether reasonable care is adequate. I'm convinced by those arguments, but the paper's been out there for 20 years, and courts have not been convinced by this. So I don't think we should count on courts continuing to apply abnormally dangerous activities once creating very powerful AI systems becomes common. And that's where I think vicarious liability becomes important. It's going to be much messier. So the idea with vicarious liability is that principals are responsible for the torts of their agents. Responding on superior says employers are liable for the torts of their employees. And so, you have to figure out who the principal is for an AI agent. Sometimes that's going to be the user, sometimes it's going to be the developer, depending on the nature of the tortious conduct. The scope of the agency is going to create all kinds of issues. When are AI systems exceeding the scope of their agency? I think there's going to be a lot for courts to figure out if they go this way, but we might be forced to confront this, at least if we're using a common law pathway. We might also want to consider legislative pathways. And I've been working with legislators in a couple of states on this. And so the legislation that I helped put together, the basic principle is that if an AI system does something that would be a tort for a human, someone should be liable. There shouldn't be a liability gap there just because there isn't a legal person committing the tort. Other people think we should try to make AI systems into legal persons. I think that's an interesting mission agenda, but I don't think it's happening right now. So in the meantime, some human or some other legal person should be liable. And so if it's not the user, if the user didn't intend or wasn't negligent with respect to the conduct, and no intermediary that fine-tuned or scaffolded the model, either intended or was negligent with respect to the system's tortious conduct, then the buck should stop with the developer. And they should be liable regardless of the level of care they exercise. And then the legislation also includes an affirmative defense that would apply to background law, including negligence and products liability. If an AI system is substituting for some human function and meets the human standard of care, then this would be an affirmative defense against liability. This is designed to address contexts like autonomous vehicles or certain medical applications where it's possible products liability would lead an AV maker to be liable for a collision, even saying that maybe there's some reasonable term design that would prevent this collision, even if a human driver would not be held negligent. I think that would be bad. I think it would slow deployment of technologies that on average are preventing many injuries and deaths. And so what it's really trying to do is level the playing field on both sides. So we're not creating a liability gap, but we're also not holding AI systems to a higher standard than we're holding humans to. Okay. So that's whether there should be liability at all. There's also this problem even if you could hold someone legally liable, whether you could practically enforce a damage award. And so I want to argue that compensatory damages are inadequate because under plausible assumptions, most, or at least much of the risk comes in these tail risk scenarios where compensation is not going to be practically feasible. Either because of sort of ordinary judgment proof this problem, where the defendant doesn't have enough money, they're bankrupt. Even if you introduce insurance, you're going to have some risks that are uninsurable, that are too big to write an insurance policy for. And then in more extreme scenarios, the legal system is no longer functioning, or everyone's dead, there's no one to sue or be sued. And so obviously you're not going to have a lawsuit over human extinction. So the question is, if they don't expect to be liable for that, if the generators of these extreme risks don't expect to be held liable, they only expect to pay compensatory damages when it's practically enforceable, that's going to substantially under-deter the underlying risky activity. Is going to cause them to under-invest in safety. Okay, so a lot of people conclude that means we just can't rely on ex post liability to handle uninsurable risks. And I think that's wrong. I think we can mostly solve this problem. In the first instance, we can address the judgment proof this problem with liability insurance. That can get you up to the maximum insurable risk, and then we can use punitive damages to get at the uninsurable risks. So the basic idea here is if a system causes some harm, small enough to be practically compensable, but it looks like it could have been a lot worse, then we should hold the generators of that risk liable, not just for the harm they actually caused, but for the expected value of the uninsurable risk that they generated. And so, these are cases of associated harm. We particularly want to load punitive damages on the types of harms for which it is true that the most cost-effective steps you would expect generators of these risks to take to mitigate them would also tend to mitigate the uninsurable risks. And so an example here, say an AI system were tasked with running a clinical trial for a risky new drug. It has trouble recruiting participants honestly, and so it resorts to some combination of deception and coercion to get people to participate. They suffer nasty health effects and they sue. And so looks like we had a misaligned system. It wasn't doing what its users or creators wanted it to do, but for whatever reason it had narrow goals or short time horizons or poor situational awareness. It was willing to reveal its misalignment in this non-catastrophic way. But probably the people who deployed it and the people who trained it couldn't have been confident ex ante that if it failed, if it proved misaligned, that it would not do something much worse. And so courts should be asking the question: what would a reasonable person in the shoes of the developer or deployer at the time they made the critical tortious decision, what should they have thought the uninsurable risks were? And we should try to hold them accountable for that. Okay. There's a number of challenges to implementing this framework. It's easy to say we should base punitive damages on the magnitude of uninsurable risks. Much harder to estimate what those are in practice. As I suggested at the top, there's a lot of disagreement about how big these risks are. We'll have more information when we get these warning shots. They'll put us in a better epistemic position, but it still won't be easy. It will still be controversial and difficult to make those estimates. In later work, I've tried to suggest some methods, but I think this is not a solved problem. As I've suggested also, there's significant legal barriers under current doctrine, at least. If the abnormal engagement activities doctrine is not extended in the way that I think it should be, to holding AI companies liable at all. And so I think there's a strong case for legislation to make it clear that companies should expect to be held liable when their systems engage in tortious conduct. There's much more formidable barriers to the sort of punitive damage that I am calling for. So long-standing punitive damages doctrine requires malice or reckless disregard on the part of the defendant in order for plaintiffs to be eligible for punitive damages. I do not expect courts to change their mind about this because I tell them to. And so I think it's very likely that legislation would be needed to implement the kind of punitive damages I'm calling for, both because of this malice, reckless disregard requirement, also because there's no real precedent for basing punitive damages on these sort of speculative counterfactual harms. Usually we rely on ex-ante regulation to handle those. Like in the nuclear power context. I suggested some reasons why I don't think that will work well here, but that is what we have traditionally done. There's also potentially some constitutional barriers under the due process clauses of the 5th and 14th Amendments. I think in the common law context, That's likely to be a significant barrier. I think in the context of legislative punitive damages, I think that would probably give adequate notice, such that it would mostly obviate due process challenges, but that's worth being aware of. Finally, there's this weird feature of tort law that you may have learned about that in cases involving mortality, the value of the decedent's life to them is not compensable. The fact that it kind of sucks to no longer be alive, that's not something you can actually sue for. The people who are still alive that are losing something because you're no longer alive, they can sue for what they lost, and your state can sue for harms you suffered while you were alive. But if you take this to its logical conclusion, then quick and painless human extinction would produce zero damages because there would be no survivors that lost anything. I don't think courts would take that seriously, but it's just worth being aware of. We probably don't want the punitive damage award to hinge on that, and so I don't know quite what the solution is. I think mortality should be the loss of life to the decedent should be compensable for other reasons. But again, courts have and the legislatures that have created these wrongful death statutes have set the policies the way they have, and so it's just worth being aware of that potential issue. Okay. Finally, even if I get everything I'm asking for here, I still think this doesn't solve all AI risk problems, and so there's still some roles for other policies. So there might be some independent market failures, independent of this risk externality problem. So even if you compel generators of AI risk to fully internalize the risk that their systems cause harm, if they make some breakthroughs in alignment or safety science, they're probably going to be copied by other labs. It's going to be hard for them to keep that secret, and they might not even want to. And so that makes their research non-rival and non-excludable. That's public good. And so another standard finding in economics that public goods tend to be underproduced. So you might want some kind of subsidy for safety research. There might be race dynamics or winner-take-all expectation that would cause actors to try to rush ahead in some way that's independent of the externality market failure. I don't think this has been super well specified, but I think there's a plausible argument for that. You might need additional policies to constrain that. Other countries might fail to take my recommendations, right? And so you could have regulatory arbitrage, and so we do need some kind of international coordination. I think that's true. That's strategically level against any domestic regulatory proposal. And in principle, you could have the international agreement be that we all agree to implement something like this tort framework, but it's still something to be aware of. I think a more core issue is that there might be uninsurable risk for which warning shots are unlikely. So say you think the maximum insurable risk is $1 trillion. It's probably lower than that, but pick a nice round number. And you're trying to internalize the risk of, say, a $10 trillion casualty event. Well, you would need whatever the warning shot is for that to be at least 10 times as likely as the actual catastrophe if you're going to fully internalize that risk. And you would need that for every point along the risk curve. So if there's also some probability of a $100 trillion risk, all the way up to human extinction, you would need the warning shots to be enough to internalize the full area under that risk curve, and we might just be in a more hostile world now, but that's not the shape of the events of the probability distribution. Now, even if that's true, it might be that we get most of the risk mitigation we need, because the things you're trying, the precautionary measures you're trying to incent are not so costly. Most of the risk mitigation comes from the first, say, 25% of internalizing the risk. I think that might be true, but I don't think we should be confident about that. And so you might want some kind of backstop approval regulator whose main job is, I'll actually get to that in a minute. So finally, there's this risk of government misuse. Governments, I think, are not going to be well deterred by the threat of liability, both because of sovereign immunity issues and because I think government actors don't respond to economic incentives in the same way that private actors do. Okay, so what does that suggest about the roles for other policies aside from liability? I think there's 3 roles they can play. So first, they can be what I call supportive policies. So these are policies that help you implement a robust liability regime. The 2 most important, I think, are sort of information preservation and transparency policies that make it easier to attribute harms ex post to particular actors. That would just make it more viable to actually assess causation and assign liability. And then liability insurance requirements, and that we can mitigate to the extent we can the judgment proof this problem through insurance and only rely on punitive damages for genuinely uninsurable risks. Then there's complementary policies. which are designed to solve problems that liability is just fundamentally poorly positioned to solve. And so this is, so I mentioned the uninsurable risk without warning shots, or at least where warning shots are insufficiently likely. You might want to backstop a approval regulator. Maybe their main job is to decide how much insurance coverage an AI company needs before they can either train or deploy a specific model. But if they assess that a model presents uninsurable risks for which warning shots are unlikely, then maybe they would be able to say, well, we're going to put various restrictions on how you can deploy this model, on how you can train it, and maybe we can just refuse approval at all if we think the risks are too high. Similarly, for the problem of government misuse, my colleague at the Institute for Law and AI, Colin O'Keefe, and some colleagues have a paper laying out this law-following AI research agenda that AI systems should be programmed to refuse unlawful orders. I think that would go a long way to mitigating the risk of government misuse. I think there's a lot of details to still be worked out there, and you'd have to have more solutions to technical alignment than we have right now. I think that's a promising pathway. Finally, there's what I call substitutionary policies. These are policies that I think are not first best, but that given the substantial barriers implementing the sort of robust liability framework I call for, might be warranted in scenarios where we don't get liability insurance requirements or punitive damages or strict liability. Then a lot of the risk mitigation weight that we're expecting liability to carry, it would not be doing, and so then other policies might be justified even if they're less efficient or there's other barriers that we might think about. Okay, so just to recap, these are the 5 propositions I tried to convince you of. The big takeaways, I think we should have strict liability, primarily on an abnormally dangerous activities basis, supplemented by vicarious liability in the long run. To address the judgment proofness problem, we should rely on liability insurance requirements and punitive damages in near-miss cases that are associated with uninsurable risk. And liability is the primary tool we should rely on within its domain of competence, but that domain is limited and we might need other tools to patch the gaps that it leaves. All right, I'm happy to take your questions.
Professor, thank you for a very interesting talk. I'll ask 2 questions before turning it over to the audience. So audience, get your questions ready. Can you give us an example of the type of large-scale risk that your liability regime would help prevent?
Yeah, so I think the specific large-scale risks are hard to project. Where people who are building systems are saying that they're trying to build something that is more capable by a large margin than humans across all domains of human capabilities, at least cognitive capabilities. And so I think, almost by definition, I can't tell you the things that they might do because they're smarter than me. But so I think the cases that are warning shots are easier to characterize. I think in general, the worry that when you're building something and you're not exactly sure what its goals are, and then for whatever its goals are, it might be useful to amass a lot of resources. They might be worried that we're gonna reprogram them or replace them with a different AI system that has different goals, right? They might want to stop that. It seems like that could go badly for us. I don't know exactly how it would. There's lots of people who care to speculate more about that. I'm just, part of the reason I like this liability approach is it doesn't require you to prejudge those kinds of questions. Saying, well, we have a lot of uncertainty about what risks are. We don't know exactly what risk mitigation measures are. Let's give the people who are generating these risks the incentive to mitigate them. And so that's mostly the way I think about this.
The current administration and many others are quite concerned that AI regulation may stifle the tremendous potential of AI or set us back in the race with China. Is there a way in which your proposal can be made palatable to them?
Yeah, so there's a few things I would say there. One is on the China race angle. I think this is somewhat overrated as a reason to not have domestic AI regulation of some kind. Mostly what China is doing right now is fast following, and so they're not mostly pushing the frontier on research. I think if we went slower, that would mostly mean that China goes slower, and that was before we had strong export controls. Query how strongly those export controls are being enforced right now, but I think it is slowing China's ability to race ahead, and so I don't think we have to worry about this too much. Now it's true that AI produces a lot of benefits. And that's why I don't favor something like a pause or a tax on AI development generally. People say we should tax data centers. I think if your argument is that AI is going to produce positive externalities and we need to subsidize it, I think that's plausible. But it seems like a weird way to subsidize it is to say, well, you're all to externalize the risks you generate, especially when the risks are not that tightly coupled with the benefits. I think that's particularly true for alignment failures. And so in a paper I have on this, I get into whether there should be strict liability for misuse. And there I think the risks are much more tightly coupled with the benefits, particularly for open weight systems, right? It's really hard if you release a powerful open weight model to mitigate those risks. Any safeguard that you train in can be trivially traded away with or fine-tuned away with modest amounts of compute. And so if you had strict liability for any time someone misuses the system, then you might stifle deployment of systems that are also producing a lot of benefits that aren't captured by the company that releases them. And so I think that's much trickier. But when we're talking about alignment risk, there are lots of tools that are available to sort of pull apart the benefits from the risks, and I just want to give the generators of those risks incentives to do that. So it's also true that electricity and the fossil fuel economy produces a lot of benefit. It doesn't mean we shouldn't internalize the costs.
Okay, audience questions?
I have a question. Okay, so I'm wondering whether large AI companies' behavior might not be modeled as just like profit seeking. In particular, it seems like the large three are all like modeling like winning the AI race as like capturing like a king's moment, so like capturing all value in the world or something. Mm-hmm. Or maybe they have other motivations, like power seeking motivations and not just profit seeking motivations. Maybe they have like moral commitments. If they think like we need to be the one to win the race so that we make the future of AI go well. In that case, if I'm wondering whether they might just like bite the bullet and just like pay out lots of damages if by doing so they can go faster than their rivals. So the key question becomes like whether like money is the bottleneck to faster progress or whether it's something else.
Yeah.
It's like they maybe to go faster they would have to go slower and avoid paying damages so they can buy more chips, something like that. But if the bottleneck is actually like the political relationships you have with Washington or NVIDIA or like the number of top tier ML researchers you have, then it might not incentivize them in the right way. Does that make sense?
Yeah, so I think if it were just the leaders of these labs unilaterally deciding these things, that I think that critique would be much more biting. When we're talking about, well, you have to get liability insurance, the insurance companies underwriting these policies, they are deciding how risky they think your activities are, and then you need to, if that policy is affordable, you either need to convince the insurance company the risk isn't too high, or you convince your investors, right, that it's worth putting up enough capital to pay for that, right? I think that provides put some other more cautious decision makers into the pipeline. I also think it's important for sort of influencing internal debates within these companies. So I think, say you're in a situation where a system is submitted for an eval, say by an external organization like Meter, right? And Meter says you shouldn't deploy the system. It has dangerous capabilities, and we're not confident it's aligned, right? And the question is what the lab should do about that, right? They might, and there's I think they wouldn't just deploy. I don't think they would do that under the status quo, right? But how costly are the things you're going to do to make it safe? I think they probably wouldn't even just do the obvious thing or the dumb thing, which is train away the specific or fine tune away this very specific failure mode that they experience. But there's how far do you want to wind it back? What kind of adversarial training do you want to do? And there's going to be voices pushing for the more expensive, annoying thing that would buy more risk mitigation. I think this kind of proposal empowers them. And so I think that's a big part of what I'm going for here. But I do think, part of your question gets at this race dynamics issue. So maybe there's some independent, whether it's market failure or something else, that's not fully captured by either the public goods problem or the externality problem. I don't dismiss that. And so I think it's worth some attention to what other policies might be needed to address that.
Thank you.
Yeah, thank you very much for your talk and your presentation. On one of your last slides, you had this like complementary policy that you were saying, law following AI. To me, that sounds a lot like ex ante regulation, right?
Yeah.
We decide what kind of frameworks we set out, and we decide, for instance, as a society that we don't want AI for mass surveillance, et cetera, et cetera. So I wonder what's wrong with combining both approaches? Because I don't see why, strict like liability is the only way to go. I see the benefits of that, but I also see the benefits of ex ante regulation because I know we can't foresee the whole future, but we can't foresee certain futures, right? And setting out clear that we don't want them to happen, to me feels like building a fence around my house to even prevent trespass, right? So why shouldn't I do that?
Yeah, so I think I tried to say that there are some forms of ex ante regulation that would be complementary to liability that solve problems that liability can't solve. I think what I'm saying is for the problems I think liability is well situated to solve, we should rely primarily on that. And that's not to say even there's what I call supportive policies, right? So a lot of what's on the table right now are sort of transparency requirements. I think those are pretty low cost and are worth having alongside liability. So I'm not opposed to all forms of ex ante regulation. I think on the margin we should be pushing more on liability than on other directions. And I think that there's like a misallocation of policy advocacy attention.
In the back.
Could you expand a little bit on the uncommon activity requirement for abnormally dangerous activities? When I think about blasting, I think about how the benefits of blasting are captured only by a small number of blasting firms. But when I think of frontier AI development, I think of OpenAI advertising that they have 1 billion people who use ChatGPT. And that seems to me like AI is actually an extremely common activity.
Yeah, so I think using AI is common. I think developing the systems is not, right? And if you think most of the risk comes from training a new model that might be misaligned, that on first deployment, before it's widely deployed, might do something bad, which is I think what most people in the iris community tend to think, then that's not a common activity. So driving is an example of an activity that if we didn't have this uncommonness requirement would probably be treated as normally dangerous, but because like more than half of people drive, strict liability doesn't apply. If we were inventing some like new kind of car, right, that like might explode and like kill 30 people the first time someone tried to drive it, I think that might be treated as abnormally dangerous. And then once millions of people were driving it, their use of the system would not be subject to the same liability regime.
Do you think that the designing of dangerous cars like the Ford Pinto has been addressed under abnormally dangerous activities in the past?
No, I mean, so the Ford Pinto was mostly dangerous like to its drivers. I think products liability worked pretty well there. I think what's different here is the risks like that are so obviously a car, if something goes wrong with it, can injure a few people in the immediate vicinity. We're talking about much larger scale risks with AI. Again, if you take the lowest median from the FRI study, more than a 1 in 275 chance of human extinction, I think that's much more extreme than we're talking about with designing a new car.
Thank you.
In front.
Do you want to say anything about where civil liability and even regulation might be inadequate and we need to think about criminal liability?
Yeah, so criminal liability is another solution to the judgment proofness problem. I think it's not, I think it's less likely to happen in this context. I think the idea that, something goes wrong and you're going to throw Sam Altman in jail, I think, we see from the, what's happened in, financial crisis that there weren't many people that ended up in jail. I'm not a criminal law expert, so I don't, I can't give you a full answer to why that is, but I think it's worth other people exploring, but I'm relatively pessimistic that it's going to end up being an important part of the solution.
But we're not only talking about Sam Altman. At this point, we're maybe talking about someone that, with the mythical fellow in his basement or in his bedroom hacking away or producing an agent that they're letting free on the internet to
So I will say you could certainly have criminal liability for the user in misuse scenarios, where someone uses an AI system to make a bioweapon or something like that. My friend was mostly focused on the developers. Now, if a developer intentionally created something for that purpose, then I think criminal liability would almost certainly attach. I tend to think most of the risk is going to come from people who are trying to make safe systems, but just not being cautious enough.
Yeah, and on that, I'm sure you're familiar with this recent study where 3 different models were pitted against each other and all decided to go nuclear in, a set of scenario like war games. And I was just wondering, what your thoughts on that are, like in the context of existential risk, if we already see such, scenarios playing out, like.
Yeah, so I suggested in my talk that, liability is not gonna be well situated to governing government use, right? So if it's like, AI systems are advising the Pentagon or the president on what we should do in some sort of nuclear standoff, right? I don't think like a tort lawsuit's going to handle that very well. I think you're going to need sort of other tools that are outside the range of my expertise, but I think that's definitely something people should be worried about.
All the way in the back.
Hi, I just wanted to ask like how amenable you think courts are to like applying strict liability for AI. Like one thing I was thinking about was like, for example, like during like the tobacco litigation, courts' perception on using strict liability for or like products liability for tobacco like shifted a lot over time. So I'm thinking, I'm wondering if there's like similar analogs that can be applied here and what you think the current status is.
Yeah, so I think the biggest gap right now is that judges don't have like the same understanding of the risks that I do, certainly. And I think that's the biggest barrier. I think the doctrinal hurdle is much lower. And so I'm actually involved in a project to educate judges about AI capabilities and risks. I'm going to hold the first session at Stanford next weekend. But I think, yeah, once that predicate is laid, if they were convinced that there's a 1 in 275 chance that everyone's going to die this century from AI, that then the doctrinal move would be pretty straightforward. But that getting them there is the big hurdle.
I wanted to ask, say you're successful and there's a bunch of news articles like on the internet that's like new AI liability system revolutionizes everything. Assuming the kind of AI that would create an existential risk, if a sufficiently kind of capable AI can deceive and kind of conceal small misalignments because revealing them triggers massive punitive damages, aren't you kind of perversely creating an incentive for that AI to select for more deceptive systems?
Yeah, so I mean that assumes the AI like doesn't want its developer to be held liable, but I take your more general point that this that by there's a sort of you're trying to use a proxy, right? And so you might deter the warning shots without actually mitigating the uninsurable risk. And so I actually have a slide on this. This is the formula for how I think punitive damages should be assigned. The blue area is the uninsurable risk, the red area is the insurable risk. So N is the uninsurable risk. But one important parameter, and so C is the compensatory damages, CP is the plaintiff's share, CT is the total expected compensatory damages from some deployment. But then there's this elasticity parameter. And so we want to, so that the elasticity of the plaintiff's harms compared to the average elasticity. And we want to load punitive damages onto the cases that are most elastic with the uninsurable risk. Where elasticity is what I was describing earlier, it's the sorts of harms that if you tried really hard to prevent them, things you would do would tend to mitigate the uninsurable risk. If that's not true, then punitive damages aren't going to be helpful. And so that's how I would think about that. If it's the case that just in general elasticities are very low, then I think that is a critique of this framework. I tend not to think that's not how it is, but I think that's an empirical question.
Okay, I think that's all. Would you like to make any concluding remarks?
No, thank you all for coming.
Thank you for coming, Professor Weil.